You're live. So good morning. This is Senate Health and Welfare, and it's April 9th. Hard to believe. Uh, Here we go. And, yesterday we didn't have the little zebra out for the rare diseases, because this is the National Organization of Rare Diseases that gave us this, and we should have had it right here to celebrate their being committed to do it. There it is. So we are on 814. This is an act relating to neurological rights and the use of artificial intelligence technology in health and human services. And we have some folks ready to testify. Do any one of you have a time problem? Good. We'll just go on the list then. And I know, Mike, you wanted to testify also.
30 seconds.
Do you want to do that first?
I would love to.
Yeah, why don't you go ahead?
Mike Fisher, can I really do it in 30 seconds? Mike Fisher, healthcare advocate. We support this bill. We were asked in the House if we wanted to participate in the advisory council, and at the time I said we didn't think so. But since then, have had an opportunity to visit with my team and think about it, and we would appreciate participating.
Being on the advisory council, which is in the bill.
Or that I did.
Okay. Well, all right, thank you. Okay, so now we can move on to Jessica Barnard, who's here. Thank you.
Good morning. Thank you for having me in. Jessica Barnard, the Executive Director of the Vermont Medical Society. My testimony won't be quite as brief, but hopefully not too long. So we want to start by framing this as saying we definitely recognize the importance of the issues that the bill seeks to address. The rapid development of both artificial intelligence and neurotechnology raise serious questions about privacy and autonomy and protecting patients from the misuse of their healthcare information, and establishing guardrails around how neurological data is used and the use of artificial intelligence in healthcare are important goals. At the same time, we would ask for some more consideration of how the bill intersects with existing use and regulation of medical technologies. So Section 1 of the bill establishes neurological rights, and it creates affirmative rights in state law, including that an individual has the right to mental and neural data privacy, the freedom of thought, non-discrimination in the development and application of neurotechnology, and the right to change an individual's decision regarding neurotechnology, among other rights. That's just an excerpt. We recognize that this section was streamlined in the House and does not explicitly create enforcement mechanisms for these rights at this time. However, this section still raises significant questions and concerns for the medical field, and we seek additional clarity of the terms in this section and the scope of the section. None of the terms are further defined. So in our view, enshrining in state statutes, quite broad and vague rights. So what falls under the definition of neurotechnology? That's not currently defined in the bill. What does freedom of thought mean to us? That is quite a broad statement. What does it mean to not discriminate in the development of neurotechnology? Which decisions regarding neurotechnology can be changed? So these are all terms that, again, while we don't dispute maybe the intent behind them, we are concerned that it's not clear what they mean or even who they apply to. So and I'm actually really glad you're hearing from the Neuro Rights Foundation. I was really impressed by their testimony. I learned a lot from them. What I heard was really focusing on concerns around the development and use of unregulated consumer products that can measure neural data. Not so much focusing on existing technologies used by medical professionals and well-established medical tests. So there are a lot of medical tests that do measure neurological data, EEGs to diagnose epilepsy or sleep studies, CT scans for many reasons, neuromonitoring during surgery, neuropsychologic or neurophysiologic testing. I don't believe it's the intent of the bill to sort of apply to rights regarding use of those technologies, but that's unclear. That type of clinical diagnostic data already falls under HIPAA and established professional standards, which have detailed regulations around patient rights. how patient data is protected, how it's released and stored. But currently the rights established in this section, again, there's no limitation in them. So they read as applying to entities and technologies that already follow HIPAA privacy regulations, creating a duplicative regulatory scheme, or even inadvertently exposing medical professionals to additional liability for patient allegations that using some of these tests somehow maybe violated what they see as their neural rights established in this section. We would recommend or request actually removing this section of the bill and deferring to the next section 3, which already tasks the Artificial Intelligence Council with reporting back regarding protections for neurological rights, protections related to neurotechnologies, and proposed definitions for relevant terminology. We think that's really important to sort of really define what we're talking about, what rights we want to have in place, what technologies that applies to. On the other hand, if this section does remain in the bill and move forward, we would request clarification that it only applies to unregulated consumer products and not to HIPAA covered entities. So one of those two pathways forward would be our recommendation. Sections 3 and 4 are specific to the Artificial Intelligence Advisory Council. We do support these sections of the bill. We support expanding the membership and role of the Artificial Intelligence Advisory Council. As I've already said, and you are well aware, the issues raised by artificial intelligence in healthcare are detailed and nuanced, and we do think justify further input from experts around the state. We support the language in the bill, adding a member with experience in healthcare, and would be happy to assist with appointing a member. We also support the report asked for in section 4 and believe it's important for a body of experts to examine and create recommendations regarding the use of AI in healthcare and the use of AI by regulated professions and by health insurance and utilization review. That said, we do have a question or a request some clarity around the overall scope of the AI Advisory Council. Our understanding of the existing statute, and I believe what the sponsor of the bill stated, is that it's specific to AI use by state government in their existing charge. But a lot of these areas, especially the new ones that the council is being asked to look at, do not, in our view, seem limited to state government. We're really talking about, I believe, talking about healthcare practices at large. And that also not my area of expertise, but looking at use in education and social services. So I guess a question for the legislature: are you intending this to stay focused just on the use by state government, or is the goal to have guidelines and recommendations more broadly in terms of how AI is being used in those sectors? Thank you for considering our comments. Happy to answer any questions.
This may be a question for Jen. Is she coming later? Jen Carvey? No? Okay. I hear your fears or misgivings. I'm sensitive to those. I also just am trying to figure out exactly what this bill does. Because the purpose section, this is a Katie bill. This is a Katie bill. Okay. Is Katie coming?
Katie. This one is Jen, 816 is Katie, but maybe this is Katie.
Okay. It says Jen, we're doing 814 right now, right?
We're doing 8. Oh, I have 816 that I'm looking at. So it's 814. 814 is Jen's. 815 is Kate's. Thank you.
I will be back. I will be here.
Thank you.
But
What does a purpose, what does a purpose section actually do? Because it seems like a lot of concerns are around the purpose.
Well, my concerns are actually around the section after the purpose.
Section 2.
Sorry, let me just make sure.
You're looking at section 2 is one you wanted to. No.
It is, oops, sorry, I have too many bills up here. 814.
There's intent, and then there's.
It is section 2, which is not, so there's the intent, there's the purpose or the intent, which is section 1. Section 2 actually creates affirmative individual rights. It says the state of Vermont recognizes that each individual has the right to mental and neural data privacy, the freedom of thought, non-discrimination. So that's adding that to exist 18 VSA chapter 42C. So that's going in statute, not in intent.
Okay, what does that do legally?
I actually asked the same question of the sponsor and legislative council. Since there's not this is my understanding. Actually, I was actually wondering whether if this, whether judiciary should actually weigh in on this, it's
Yeah.
really a question for the
Right.
Judiciary Ledge Council. If we're creating rights in state statute, we're not giving a new mechanism to enforcement. My understanding is that somebody could still go to court seeking at least declaratory or injunctive relief. So meaning not necessarily get a moneyed award, but could say, I think this right is being violated. I want them to stop doing what they're doing, like an injunction. Or I want a declaratory judgment saying that, just stating, yes, you have violated this statute. I don't think it's meaningless to put rights in state statute, you know what I mean?
I guess I'd like to.
Well, it's the word right that is of concern here, so we'll have to talk with Ledge Council about that, and there are a huge number of implications depending on how you read it.
Right.
I mean, I think about the whole judicial process.
Right.
I think about competency, I think about all of those things. And so this will become,
Right, I mean, that
Place
saying
us.
each individual has the right to freedom of thought, that just seems so broad to me. I don't even know sort of how you would.
of Rights covered that.
Well, there are,
Depends on who you are. Okay,
Okay,
all right, so
fascinating.
it's very interesting. The bill raises a lot of really interesting questions, and happy to, stay engaged as the bill develops.
Good.
Thank you.
And
Thanks
then
for having
wanting
me.
more focus on the study group.
Yes.
I get, yeah.
Yeah.
you'll work.
so on the study group, are you already on the
We are
council?
currently we are in language that came from the House, stating that one member with experience in healthcare appointed by the Vermont Medical Society would be added to the council. And we support that.
You know,
We didn't even request it. We were very honored. That was a suggestion of the sponsor of the bill.
Good, all right. Okay,
Thank you.
any other questions? You've got lots of testimony here from you, which is helpful.
Thank you very much.
All right, thank you. Ashley Collins. Nope, Sean. It's Sean. Good morning.
Hi there. Good morning. Can you hear me?
Oh, yes, we can. Sean, we're going to introduce ourselves briefly around the room. So you know with whom you are speaking, and then we'll ask you to introduce yourself as a representative of the Neural Rights Foundation. So
John Morley from Orleans.
John Benson, Orange.
Ginny Lyons, Chittenden Southeast.
Martine LaRocque, Chittenden Central.
In Cummings, Washington District. And thank you for being here. So why don't you introduce yourself for the record, and do we have testimony from you? We don't yet, but once you've given your testimony, can you submit it so that we have it on the record?
Yes, absolutely.
All right, thank you. So why don't you go right ahead?
Okay, yeah. Well, thank you so much. My name is Dr. Sean Pazowski. I'm the medical director at the Neural Rights Foundation and a practicing neurologist. And just so grateful for this conversation today with all of you. I care for patients with stroke, brain injury, and disorders of consciousness. Patients whose ability to communicate, decide, and advocate for themselves is often impaired. And that clinical reality shapes how I think about this bill. Because at its core, this legislation is about protecting individuals in moments where they're most vulnerable and when the systems around them matter most. And I think this bill addresses several important areas, including artificial intelligence in healthcare, patient communication, utilization, and review. Those provisions are timely and necessary. But I'd like to focus my remarks on what we've sort of already started talking about today, and that is what I think is one of the most important aspects of this bill, and that is the recognition and protection of neurological rights. The bill proposes to establish privacy standards for neural data and to define protections around how technologies interact with the human nervous system. And I think this is significant because neural data is fundamentally different from other forms of health data. It's not just information about the body, it's information generated by the activity of the brain and nervous system, the biological substrate of thought, intention, and experience. And in clinical practice, we're already seeing the early stages of this shift. Technologies are being developed that can detect patterns of attention, fatigue, assist patients in communicating through neural signals, and interpret brain activity in ways that were not possible even a decade ago. And these advances hold tremendous promise, but they also do raise these new questions. Who owns the data? How is it used? And what are the protections in place to ensure that it is not accessed or used inappropriately? This bill takes an important step by recognizing that these questions are not theoretical, they are emerging now. By establishing privacy standards for neural data, Vermont is acknowledging that existing frameworks may not be sufficient for this category of information. That is a forward-looking and appropriate approach. The bill also addresses the interaction between electronic devices and an individual's neurological activity, and this is another critical area. As technologies evolve, the boundaries between observing neural activity and interacting with it become increasingly important. Ensuring that this interaction occurs within clear, regulated boundaries is essential to maintaining trust in both medical and technological systems. From my perspective as a neurologist, this is not just a technical issue, it's a clinical and ethical one. Patients entrust us with their most important information, and that information begins to include data derived directly from the nervous system, and the stakes increase as this happens. The artificial intelligence provisions in this bill are also important, particularly those related to transparency in patient communication, oversight of mental health tools, and limitations on automated utilization review. These provisions reinforce a consistent principle. The technology in healthcare should support, not replace, clear, accountable, and patient-centered decision-making. But what distinguishes this bill is that it goes further. It begins to define a category of rights that are specific to the brain and nervous system, and that is where I believe its long-term significance lies. Finally, the bill strengthens the role of the Artificial Intelligence Advisory Council, extending its duration and expanding its responsibility to evaluate the ethical and responsible use of AI across healthcare, human services, and education. This is an important mechanism because the issues addressed here will continue to evolve. Ongoing oversight ensures that policy can adapt as technology advances. In closing, I would emphasize this. We are at an early stage in the development of technologies that can measure and interpret neural activity. The decisions made now will shape how those technologies are used in the future. This bill does not attempt to solve every challenge, but it establishes a foundation, one that recognizes the uniqueness of neural data and the importance of protecting individuals as these capabilities develop. From both a clinical and policy perspective, I believe that is a meaningful and necessary step. Thank you for your time, and I welcome any questions.
Thank you. I do have a question. One of the things and I appreciate your input on this, and I would be helpful to have you as we go forward and modify the bill and look at the language of the bill. One of the things that you said was you talked about the privacy standards of neuro data. So we're talking in here about protecting that data. That's one. And that very much to me relates to HIPAA. You know, it could be HIPAA data, healthcare data that's being protected. But then our discussion that we just had was respect to the neuro rights, the rights of individuals. So I'm trying to discriminate between what you're talking about as privacy standards for neuro data and the rights of individuals. So at what point does the individual right take over when a clinician is utilizing individual neuro data in decision making in whatever arena it is, whether it's in the judiciary or the healthcare arena or others? I think that there seem to be some boundaries that need to be defined there.
Yes, absolutely. And that's that's a great question. And I actually have a kind of a show and tell here that might help make it more sense. So this is a consumer device that you can see here, these headphones that have these lines here. These are brainwave sensors. And I ordered this off of the internet. So you can see that, I practice neurology, it is my profession. And what I'm collecting from patients in the hospital, I can just bring home and put on my head and be collecting my own brain waves. So you're absolutely right that the tension, the real peril here, the real loophole that we're trying to address is that you can have medical grade data in a complete consumer setting. Anybody can do this off the internet, order devices. There are dozens of these devices out there. They're proliferating very rapidly, already in the billions of dollars of sales and set to grow exponentially over the next 6 to 8 years. We're talking, growing by leaps and bounds here in the future. So that is exactly where the issue lies, is that HIPAA does not extend protection to the data collected from these headphones that my patients are using. And so that's actually how I came to this area. Is I was approached about a research study using one of these devices for the management of epilepsy. And I said to myself, if I can get this device that I'm using in my study off of the internet and a patient at home is using it, then what's to say what can happen with that data? And so that was really my personal, experience with this. And I should add that the American Medical Association last year, as I'm sure the Vermont Medical Society, is aware or may be aware, adopted a policy to define neural data and to protect it, to designate it as a category of data deserving protection. And I'm happy to share that policy from the AMA that was adopted by consensus, including all 50 state medical societies at the AMA meeting. And so this is already getting some traction in the medical community. And but you're absolutely right, to the point of where's the philosophy and where the rubber meets the road. I think that's kind of like the tension of like what we're talking about right now is, I don't think anybody would be against the idea that people should have rights to their brain data. I mean, it's your brain, it's your most sensitive personal information. It can tell you all sorts of different things about your health conditions, your personality. It's really just, set to become a part of daily life. And so we're trying to get ahead of this before any misuses or abuses happen. So that's really where we come at this from. But that's a great question.
Okay, this one we're gonna probably struggle with a little bit in here. But do send us the AMA policy. I think that would be very helpful. The protection policy, the zero data protection policy that you talked about. It feels to me as if we're struggling with two things. To separate it even further, we're looking at the data that you collect when you're with a patient or from a patient. And then we're also looking at the more general data that's out there in the real world that can be collected regardless. So the internet defines.
Yes, that's a good point. And there's actually, I wouldn't call it so much of a debate. I think there's pretty clear standards on what neural data is and what it isn't. We define neural data as electrical activity, data collected from the activity of the central or peripheral nervous system that's not inferred from this non-neural information. It's important to draw this distinction because, the closer you go to the source, to the brain, it kind of makes intuitive sense that the more you can derive from that information, you can maybe infer things about people from their online activity, things of that nature. But we're talking about degrees of sensitivity. And like I can put it, these sensors, I actually, talk to these companies and they show me things all the time that really are amazing in terms of the sensitivity of the things they can detect, conditions that you wouldn't otherwise have any access or any knowledge about what's going on in someone's brain, but you put these headphones on and you can tell if somebody has OCD, Parkinson's, epilepsy, Alzheimer's, depression, anxiety. I mean, all of these things that are just going straight to the source. So you're absolutely right. That category of data deserves protection, but we believe that neural data has a unique sensitivity that deserves unique protection.
Thank you. This is a good conversation, and I think it's one we're going to have ongoing as we go through the bill. Senator Benson has a question.
So you said the AMA has some guidelines here. Are you aware of any other state that has taken this on and created a similar bill?
So yes, so I would say that Vermont has an opportunity to make a historic step in this regard, and that this bill is unique in comparison to the previous bills that have been passed. There's legislation currently passed in the state of Colorado, California, Montana, and Connecticut have all adopted bills with very, very consistent strategies, amending state privacy acts, which I think we started talking about, initially about the teeth and the consequences and the enforcement aspects. I mean, those are all open questions, but this would be the first neurological rights bill in the country that would take its kind of standalone step to enshrine these rights, is standing outside of any kind of privacy law frameworks. There are also international standards. The country of Chile passed a constitutional amendment in their constitution with a very similar strategy to what we're discussing today. An act to essentially protect the rights of the mind and the brain, and the nervous system in their constitution. There are also several countries. The country of Canada just did something similar, and the state of Rio Grande do Sul in Brazil. So this is really getting traction in the Americas. But to your question, the 4 states are Colorado, California, Montana, and Connecticut have all passed something similar. But this would be an historic opportunity to tie it to kind of a more broad philosophical framework and really address these issues from that perspective.
All around Montana.
California, and then
Can you list those states when you send your testimony?
Absolutely.
Yeah, that would be helpful.
Maybe the countries as well.
And then there's something about the countries, the distinction between the rights and the privacy, constitutional amendments and laws. So there's a different distinction there.
Yes.
Okay, thank you. This is really, any other questions? I think we would like to have for you to come back at some point after we've had an opportunity to look at the testimony you send in, to help us and help guide us through markup and changes to the draft that we have. That would be really helpful.
Absolutely. And we're happy to work with you on definitions of these terms. Like that's something that we're very happy to do as well.
Terrific. Okay, that's helpful.
That's one last question.
Go ahead, Senator.
What, has Europe done anything around this topic?
So Europe is, yes, they're in the early stages. The GDPR is, like the Broad Privacy Act that covers, I think, the entire European Union. I would defer to my colleague Ashley Collins on some of the more fine details about that, but they are discussing this. The UN is taking action, as well as there is a state in Spain, in the north of Spain called Cantabria, that has a bill developing as well. So also starting to get some traction in Europe.
Spain. Wow,
Thank you.
very good. Thank you.
Yes, thank you.
Thank you very much. I mean, this really helps get us off the ground. We haven't gotten to the moon yet, but we're going to. Thank you.
Yes, thank you so much.
All right. So, and please do send your testimony and any links to, what other states and countries are doing. That would be very helpful.
Absolutely. Yeah, we'll get that to you.
Thank you. All right. And we have Ashley Collins here from the Neural Rights Foundation. There she is. Okay. Ashley, thank you for being here. We introduced ourselves earlier, so I'm hoping that will sustain you. And then you've heard some of the discussion, but why don't you go ahead with your testimony and please, when you finish, at some point, it would be great to have your testimony in writing so we can post it on our webpage.
Certainly, yes.
Thank you.
Great. Well, good morning, members of the Senate Committee on Health and Welfare, and thank you for the opportunity to speak. My name is Ashley Collins, and I'm a human rights lawyer based in Washington, D.C. I serve as a legal advisor to the Neural Rights Foundation, which, as you know, is a nonprofit organization with the mission of promoting innovation, protecting human rights, and ensuring the ethical development of neurotechnology. Over the last 5 years, the Neural Rights Foundation has engaged stakeholders such as the United Nations, governments around the world, scientists, the tech industry, and lawmakers in an expansive effort to establish guardrails capable of safeguarding neurotechnology users. And the bill we're discussing today is important in our view, in the view of the Foundation, because it highlights the fundamental rights that must be protected as neurotechnologies advance. As a starting point, and I think as I've shared in previous testimony, to understand the risks associated with consumer neurotechnology and the importance of robust protections against the abuse and misuse of this technology, it's helpful to examine the current regulatory landscape. There's a significant difference, as my colleague Sean was elaborating on earlier, between the regulation of invasive neurotechnologies on one hand, which are implanted in the brain through surgery, must be licensed medical devices, and whose gathered neural data is generally protected under health data privacy laws like HIPAA, and that of wearable neurotechnologies, on the other hand, which are subjected to little or no regulation, even though such devices are also medical grade. There are more than 30 consumer neurotechnologies available for purchase today, as you saw during my colleague's testimony. And in terms of the future, it's important to highlight that researchers have already used wearable neurotechnology devices combined with generative AI to decode thoughts to text with increasing accuracy. So I think it's really important that in this bill, we're looking at the issues of artificial intelligence along with neurological rights and neurotechnology. It is possible that devices to decode thoughts to text and others like them will be improved in the next few years and could even be used in consumer devices eventually. The gaps in regulation are concerning given the extreme sensitivity of neural data. It's important that the bill under consideration calls on the Artificial Intelligence Advisory Council, along with other stakeholders, to review the guidelines and recommendations of the American Medical Association, among other professional organizations. As my colleague shared, the American Medical Association has adopted a resolution on safeguarding neural data that should be, in our view, carefully considered when the council eventually issues recommendations. It's critical to carefully review guidance from these experts because neural data is capable of revealing such intimate information about consumers, including information about individual mental states, emotions, and neural processing. The sensitivity of neural data and the imperative of its protection heightens privacy risks posed to neurotechnology users. Because neural data contains distinctive information about the structure and functioning of individual brains and nervous systems, it always contains sensitive information that can link an identifiable individual with their data. And some of these devices are capable of revealing information about mental and neurological diseases and decoding about a dozen different mental states. This is deeply intimate information to entrust companies with, and without protections in place, it will be entirely up to those companies to decide what they do and do not do with their customer-sensitive neural data. And to give a sense of the approaches taken to protect neural data, and as I think you were just asking my colleague about the efforts undertaken in different states, in the United States, 4 states, as was mentioned, California, Colorado, Montana, and Connecticut, have taken important steps to protect consumers who purchase and use neurotechnologies. In California, an amendment to the state's consumer data privacy law defined neural data and then protected it as sensitive personal information. This allows users of these technologies to request, delete, correct, and limit the data that neurotechnology companies collect from them. And they can opt out from companies selling or sharing their data. In short, companies in California will now have to treat neural data with sensitivity so that it does not enable undesired disclosures of information or unwarranted violations of privacy. And while the exact approaches of US states have differed, legislation has generally followed this format of defining neural data and then extending the protections of state consumer data privacy laws to protect it as sensitive data or sensitive personal information, depending on the exact language used in the legislation. And one thing I will note is that the NeuroRights Foundation does have a briefing note that we often share with legislators that really breaks down the differences between these 4 states' efforts to protect neural data. And that's something that we can share with the committee afterwards. It sort of gives you a bit of the history of how some of these laws came to be and the sort of key points behind all of them. So it will give a sense of what California does versus what Colorado does versus Montana, Connecticut, and so on, and along with our recommendations around that. At the international level, UN entities have also urged action and begun to provide recommendations on what can and should be done to prevent the misuse and abuse of neurotechnology. This includes the UN Human Rights Council's adoption of Resolution 51/3 on neurotechnology and human rights in October 2022, the UN Human Rights Council Advisory Committee's August 2024 report on the impact, opportunities, and challenges of neurotechnology with regard to the promotion and protection of all human rights, and the UN Special Rapporteur on the Right to Privacy's January 2025 report on the regulation of neurotechnologies and the processing of neurodata. All of these reports and resolutions take a human rights focus to these issues, which I think underscores the importance of the bill's framing of neurological rights. These are, at the end of the day, human rights issues. Therefore, and based on the NeuroRights Foundation's experience engaging on these matters with stakeholders around the world, we believe that efforts to establish legal and regulatory frameworks to protect citizens from the potential misuse or abuse of neurotechnologies, especially in unregulated consumer products, must be rapidly accelerated. Laws and policies around the world, including in Vermont, will need to adapt to address the serious human rights concerns raised by the dissemination of neurotechnology, including in relation to the issues of privacy, surveillance, fair access, algorithmic bias, and safety. While neurotechnologies hold immense promise for deepening our understanding of how the brain and nervous system function, they also create significant risks. And as we continue to consider the development and deployment of neurotechnologies in the United States, we should do so with an awareness of both their promises and perils and a commitment to advancing common sense steps, starting with this bill, to protect all patients and consumers. Thank you very much, and I'm happy to take any questions you may have.
Thank you. This is really helpful. It's a nice sequence from Sean to you, and please do send your testimony in to us. Very helpful. We have a question from Senator Morley.
Yeah, Ashley. So hypothetically, somebody gets hold of my neurological information. What are the companies going to do with that information? What are they going to do with it that's really going to harm me?
I mean, I think a lot of well, I guess as a starting point, the companies do use the data in order to make the products function. I think as Sean alluded to earlier, different neurotechnology devices can be used for different purposes. Some of the products are used to help people with sleep. There are devices that are focused on meditation, and so they collect all of this data to help with those purposes. So some of the collection of data is for the functioning of the device and for the services that you've purchased the device for. But sorry?
I was just going to say, it sounds like it could be used for marketing purposes.
It could be. That is one additional use. Because I think one of the concerns around the collection of neural data is that these devices are collecting a massive amount of data. It's not sort of just the data that is used for sleep. It's all of the other data. It's data that could eventually be used to decode, what were you thinking at a particular moment in time when you were using this device to, say, help you with meditation, right? It's collecting much more data beyond just the data that pertains to the specific service that the device is supposed to provide. And so that's
don't get me wrong. I don't want them to have my data. But I'm just trying to think of how companies are going to somehow misuse it. I guess marketing.
Well, marketing, but it also could be used to understand your intent and what you're doing. So, I mean, if in the public safety, criminal justice arena, it could be used to demonstrate that you intended to do something in a court procedure when maybe there was a good defense on your behalf. I don't know how that could be used. So Senator Gulick wanted to comment, and then we'll go back to Ashley.
I always just wonder if like an insurance company can see that you have a pre-existing condition and they can decide we're not going to cover this guy. He's got this whatever. Yeah, so that kind of.
I certainly don't want anyone in my head anyway.
Right, or a body. I mean, body too.
Yeah, I think you're all raising, very important concerns, and I think they're all sort of pointing fundamentally to an issue with sharing neural data, right? So you may purchase a neurotechnology device to help you with sleep or meditation or, whatever it is you're hoping to gain a benefit from. But if that company is holding onto the device, who can that company share your neural data with? If they have it and you're comfortable with that company having your data, you may not necessarily be comfortable with them sharing that data, selling it to another to a third party, for example, because that's where you start to lose control as the consumer, as the owner, of your own data. You start to lose control over who has access to potentially your most intimate thoughts. And so I think a lot of the the concerns end up being around the sharing of neural data, the selling of your neural data, because the further it gets away from you, the less, control you have over it. So I think that's a bit of the bottom line on what the key concerns are around what the companies can do with your neural data.
Thank
Not
you.
necessarily the companies collecting them sort of at the first level.
Thank you. We're getting deeper and deeper into the thinking process on this one. Thank you very much. Appreciate it. And so please, if you have the time, and we may reach out to you again to answer questions as we go through the bill, that would be very helpful.
Certainly. We are always happy to answer questions, provide additional information. As I noted, we will send our briefing note that provides an overview of the different approaches that different states have taken in the United States, and we're happy to answer additional questions about our efforts, about other efforts to protect neural data and neural technology users around the world. So yes, happy to answer any further questions that you may have.
Thank you very much, Ashley. Appreciate it. So, thank you. So, Rick, I'm going to ask you, could we take a hiatus and move to Senator Brock, who's bringing us an amendment? Said then we'll come back to both bills that you were here to testify on.
Absolutely. Mine is going to be on 814 as short as Mike Fisher's was. So yes.
Oh, well, if you're doing 814, that short, why don't you come up and do it?
Okay. I can do that real quick.
It's also relevant for them to hear the.
I know.
Yeah. I can send you.
Okay.
Hi.
Hi.
Rick Barnett, licensed psychologist. I'm the representing the Vermont Psychological Association as the chair of the legislative committee. And we fully support H814. It's really interesting to hear all the testimony this morning. Some of it above my pay grade, but it's still very interesting. And like Mike Fisher said, and as Jessa had mentioned, the AI Advisory Council and the board seems to be a very important piece of this bill. When I testified on H814 in House Health, I asked if the Vermont Psychological Association could be added to the council, and I'm asking again because mainly because the American Psychological Association has a national, well-respected mental health organization with over 100,000 members has done a lot of work on AI. They have policy statements as in conjunction with the American Medical Association as they have policy statements. So adding someone from psychology would be great. And that was my ask.
Thank you. Thanks very good.
Thank you.
It was short.
Thank you.
Thank you. Good. Okay, so we'll just take a little breather here. And we're going to move, Senator Brock has an amendment. It's a finance committee amendment. So why don't you come on up? Senator?
Finance has
Well, so if I just want not to see it.
Then we won't see.
Do we have it? We have
That's
it.
amendments are those that haven't been read before they're introduced.
Here it is. Okay, now we have a copy of your proposal. And why don't you share the proposal with us?
I'm Senator Randy Brock of Franklin County and part of the northern part of Grand Isle County. Thank you, Madam Chair. This is a proposed amendment to H 237, which is a bill that allows certain psychologists to provide medication or to authorize medication for patients that normally might have been provided by psychiatrists. This is in theory, it's a simple, and the bill as originally states says that the prescribing authority will not be given to a person over 90 years of age. And 90, actually 80, I'm sorry, you're right. It's 80 years of age. And the problem that I see with that, and the reason for the amendment, is that there are a variety of federal laws, including the Age Discrimination Act of 1975, and also some provisions in the Medicare law, simply say you can't make a prescription for someone, you can't provide or deny treatment of any particular kind to an individual solely on the basis of age.
Now, when there are other conditions that are attached, such as the prescription history, medical history of the individual, and a variety of things, that you can prescribe different things, for example, for older people under certain circumstances. What this amendment does is it simply says that it is okay to exclude the authority to the psychologist to dispense, administer, or distribute prescription drugs. In other words, the psychologist is not a pharmacist, and so the act of distribution is prohibited. And then secondly, to prescribe or discontinue prescription drugs for patients who are less than 18 years of age or pregnant. It then adds another paragraph that deals with the advanced age. And a number of people have said that people with advanced age have a higher likelihood of having certain kinds of problems or issues based on their treatment by a psychiatrist in these kinds of circumstances. And what this does is it simply says that you can't discriminate a person solely on the basis of age, because some people at age 80 have a problem, some people at age 80 do not. There are other people at age 60 who have a problem, and there are others who do not. And so what this does is it adds an additional qualifier that says the written collaborative agreement has to be done between the psychologist and the psychiatrist should contain a protocol for the completion of a clinical risk assessment of each new patient prior to treatment that specifically includes a review of prescription drug interactions and physiological considerations. It's designed to be not tremendously prescriptive in terms of how that review is done, how the information is collected, just simply that it is collected. And it's envisioned that the groups involved, I've spoken to both the psychologists or representatives of the psychologists and the medical community, and I see that there are disagreements between the two. And I make no position one way or the other as to whether that is or is not an issue. I'm solely focused on the issue of the legality of doing it in the way that is done in the bill. And from a fiscal standpoint, from the finance committee standpoint, it is that if it's not done well, it's going to be very costly for the individuals concerned and conceivably very costly to Vermont. We'll pay for a great deal of medical treatment. That's it in a nutshell.
Okay, thank you. And we'll look at it. We'll have Ledge Council come in and we'll look at this with respect to the bill that we passed, understanding that are you presenting this as something that the finance committee is supporting? Is this an independent proposal from you as an individual?
That depends on how the finance committee votes this afternoon or late morning when we present it to the full committee. I've certainly presented it to the chair and a number of members of the committee.
Yes, the committee doesn't have doesn't have to.
This is not really, yeah, and it's a bill is going out of the committee. This is, it also feels very much like healthcare jurisdiction.
I agree.
As you know, so.
I agree. And it's not the intent to interfere with the jurisdiction.
Understood.
However, you know, as I mentioned, I'm focused from a fiscal standpoint on what is this going to cost and who's it going to cost? And there is.
So do you have a fiscal note that comes along with
I don't,
this?
but I have what I said.
That would be good. All right. I mean, if it's going to be from finance, there has to be some financial implication.
And again, after further consultation with the committee, I'm certainly happy to produce the amendment as an individual. Yes.
Yeah, this is, finance committee doesn't have jurisdiction. We voted the bill out. So with any amendment,
To be on the floor.
it can be.
People
from
sign on.
One or
One or more.
several members can sign on individually, but it's not a finance committee.
Yeah, it
Understood.
replaces an amendment that is a
Right,
finance
that
committee
is,
amendment.
yes.
That I've withdrawn that amendment,
Right.
which did pass through the finance committee and done this more limited amendment that I believe better conforms with the law.
I think this has been a work in progress that a lot of people have been involved in.
Thank you, Senator.
Nice.
All right. Okay. And Katie has come in. I think what we'll do is, Katie, do you mind coming up and sort of talking about this proposal amendment?
Yes.
Integrated into our.
So it's a third reading today, right?
Yeah.
It is third reading, and Martine is the
Yeah. report.
Jeff on this one.
So,
I've done my.
She did a good report yesterday. Thank you for that. And then, so we need to look at this as it fits into one stuff.
We deciding if we as a committee support it, right?
So we're gonna do a little straw vote, whether or not we support it and what effect it has on the bill as we pass it out and as was voted on for second reading. We're not taking testimony on it.
This
We
is
are
where
listening
you
only to
use neurological data. Because there is, at what point are you so overwhelmed you'll vote for something to make it go away? It could be really,
That's kind of what he said.
I'm sure I've been in brainwaves.
Where's that little headset?
no other brain, that's what happens.
In all fairness, you're coming.
Hello, good morning.
So we have this and it fits into section 1.
Yeah, I'm pulling up the document right now.
I've got my calendar for yesterday. That I'm looking at, or April 3rd that I'm looking at.
Okay, you can share my screen. Okay, here is the amendment. You have it in front of you as well. So what the amendment does is in the definition section, it strikes out the existing definition of prescriptive authority, puts the definition back in, but in subdivision B without a limitation of 80 years of age. So
it takes out 80 years of age and
then in the second instance of amendment, that's in section 3, there's an existing subdivision in C1. Let me catch up with you here in my hard copy. Oh, that's why it's not in this file, because I was coming in to talk about AI. There is an existing sentence about written collaborative agreements in subdivision C1, and this adds a second sentence. Besides just requiring that there's written collaborative agreement, this says that the written collaborative agreement shall contain a protocol for the completion of a clinical risk assessment of each new patient prior to treatment that specifically includes a review of prescription drug interactions and physiological considerations.
only for new patients. So any changes that would occur to a patient going forward wouldn't be included.
I don't know if it would happen as a matter of course, but this language is specific to the intake of new patients and having this assessment done by the collaborating practitioner.
At the risk of opening a can of worms or two questions. One, does this collaborative agreement trump the exclusion of the pregnant people and the under 18s?
No.
Okay. And the second question is, who is going to develop a protocol? Is that going to be up to each individual physician?
I know you don't want to take testimony, but I really can't answer this question. The sense I got from the advocates was that there already were protocols in place to do this type of clinical risk assessment and that this wasn't necessarily a new concept. But I certainly am not in the field, so it would be better to hear that from somebody in the field.
Okay.
It could, seeing that OPRs walked in the room, I will.
I may.
Comment, we're looking at a proposal from Senator Brock on H 237 and Katie, why don't you just read through that paragraph?
Right. So this is prescribing by doctoral level psychologists. There's already a sentence in the bill that requires a written collaborative agreement. And this adds a second sentence that says the written collaborative agreement shall contain a protocol for the completion of a clinical risk assessment of each new patient prior to treatment that specifically includes a review of prescription drug interactions and physiological considerations.
Right. The other part of the proposal takes out the age of 80 in the prescriptive authority. Just so you know.
Okay, and you're asking for our opinion on this?
Well.
Okay,
If you would like to share any, I mean, this bill has been through a significant amount of work, both outside and inside this committee, and I'm really loath to make changes to it, but I'm willing to listen if there are.
So, Madam Chair, if I can, for the record, Lauren Hibbert, Deputy Secretary of State, and this is the first moment that we're seeing this, so I just want to be clear, and I think our opinion reflects what you just said, which is that this has been through a significant process. Most of our statutory language, when there is a collaborative agreement, does not dictate specific elements of the collaborative agreement. It assumes that there are two professionals involved in entering into that relationship, and that will be a relationship of trust and reliance, which is the purpose. So that being said, if this is a deal breaker for the Senate, I don't know what the.
Well, but we're not go there.
Okay.
This is our committee making that decision. So,
Jenny,
go ahead.
I might. This bill came to finance.
Yes.
I voted no on the bill, both in here and in finance. Full disclosure. I'm feeling better about the bill as I've learned more about the collaborative agreement. Senator Brock was very concerned about putting the age of 80.
Yes, I remember that.
Yes. And he has done extensive research into federal anti-discrimination laws. And so he's trying to find a way to say, yes, for some people at 65, which is where geriatric patients usually start, because we have adolescents, which is 18, you can prescribe for children, but he wants a way around it. My suggestion was, because this was not within the jurisdiction of finance, but the committee did vote for it, that they just would say the psychiatrist and psychologist or the medical society and the psychological society will develop a protocol for when it would be appropriate for that, for the psychologist to be able to continue prescribing. I think that's what Randy is trying to do. I'm not sure.
So the question is, do we support this as a committee, and any other comments on that or questions for Katie?
That was my question.
That was your comment.
Yeah, I think that's what's going on.
So it's something different than just asking from PR, right? So he's going about it a different way than.
Correct. And but I'll just say that this doesn't have anything to do with age. This is for every new patient.
Yeah,
Yes.
it is much broader, and it's not a general protocol that would be used in evaluating older patients.
So
It's focused on each collaborative agreement will have it. It hits at a lower level than a general protocol.
So, any other questions?
So.
I'm looking for a straw poll on this. Those of you who would like to support this on the floor, can you just raise your hand?
Could we do a substitute amendment?
And no?
Are you kidding? I'm the one that just wants it to go away.
Those of you opposed to this, please raise your hand.
I
Opposed
mean,
to-
I'm opposed because I think they did a lot of great work, and
Right.
I don't think we did.
Okay, just need to know everyone's opinion at this
I
point.
think that this is gonna happen.
Right, OPR is gonna do this one. Are you supporting it or against
I'm
it?
abstaining.
No, you
You
cannot.
cannot say.
Not unless there's conflict of interest.
My only
Proclaim them.
concern, Randy, you're raising the question about having the actually 80 specified in there, and if that does expose
That's sort of
the
a
state.
state.
losses.
We
Exactly.
also have 18 years in there, and we have pregnant individuals. And I'm looking at Katie about all the issues around age discrimination. This rather, for me, I'll just give my opinion about this. It looks at the age of 80 as a time when people were heard from the data that there may be more polypharmacy, that people need better care. And by putting 80 in there, you're actually giving greater care to the individual. It's not lesser care or depriving. It's saying maybe they have a new prescription and psychologically begin to demonstrate characteristics or symptoms that a very capable psychologist might misconstrue and want to treat with another additional drug. So rather than do that, there's an opportunity to look at the individual and say, oh, it's not it's a byproduct of the treatment that the individual is getting. It's not a new psychological, it's not a new event. So
could it be age discriminatory in your legal opinion?
The language in front of you on the amendment is
Yeah, no, that.
neutral. I know, I'm getting it. Is age neutral.
Yeah.
When there is an age, it needs to have a basis for why that age in particular. We're talking about a medical process. So is there a medical reason for that particular age? 18 is a little bit different because I think there is agreement in the medical community that pediatric brains are developing differently than adult brains. I'm not a scientist. I'm not a medical professional to tell you if there is the same medical agreement about the age of 18.
You may not know, so I'm for the event.
well, we do know that 65 is the recommended age for geriatrics. So we could recommend putting the age of 65 in rather than 80. And that would upset the apple cart on this side of the psychological association. And so this is an agreement that's come to. I'm feeling fine with
Leaving it alone.
Yeah.
Okay, I think Brady may have some validity to the 80. And like Brady, I may be more sensitive to that age than others. But I think this may be for each patient. I think this, I could vote for this to move it forward. If the House would ask for a committee of conference, then we probably could fine tune the language. We could do that with the original.
So here's my question. This is the question I've asked. I want a straw poll. This is the end of it because we have other things to do. And we've talked about this 100 times. Go ahead, Senator. The last question.
And this is, we're not really talking about the patient. We're talking about, we're giving authority to.
Prescribing psychology.
Right.
Yeah.
And so what we're saying here in that bill, 80 says, then maybe you need to do something different. So it's not actually against the patient, it's actually against the individual, so they can get further treatment, but maybe can't come through that meet. So in essence,
Go through it again.
I'm not sure that it really is an issue.
Thank you. Good point. Apparently the majority.
But I'm not the attorney.
Well, but so strategically, if you think it's gonna pass, I want to vote yes, so I can be on the comments committee.
Okay, I am going to ask you right now, in the context of all the work that we've done on this bill and what you've heard, how many of you would support this proposal of amendment? Straw vote. What, this amendment? You want to move this amendment forward?
if that's what moves the bill.
If that's
No,
what
I don't know anything about what's gonna happen upstairs. That's not what we're considering here. We're not considering a conference committee. We're not considering a vote on the floor. We're looking at this in context of the bill that we've written. And this is significantly different from the bill that we've written.
If we vote no here, will you stand up and speak your mind to the amendment so that people?
I will speak my mind.
Okay.
I have been known to.
you've done that 3 days ago.
Okay. Because that,
No, that wasn't the time.
all right.
All right, I want to see all those who want to do this. Word, see
Support the amendment. I'll support the amendment.
all those opposed. Well, the majority of the committee.
No, I understand.
That's it.
I'm
We're done.
abstaining, given my.
You're gonna-
How am I abstaining? You wouldn't want me.
Other, I haven't got a reason. The senator, secretary says I'm all power.
Okay, we're good.
Which this
Thank you,
amendment
Katie.
proved I have not.
Katie.
I like this better.
All right,
than the
we're moving
original,
on
but
to H8:16, and I know that Dr. Barnett has disappears at 10:30. So why don't you come up and then we'll go to the rest of the folks on the list. Thank you. And Lynn, we'll go to you next. Here.
Hello again, Dr. Rick Barnett, licensed psychologist, representing the Vermont Psychological Association as the chair of the legislative committee. It's hard to follow that busy discussion. Been only working on that for a decade, but anyway.
We know that, and so part of the work that you've done, thank you for that.
Thank you, guys. Thank you very much. I did submit written testimony for H816, which I'll speak on now. I submitted that before I was asked to come in and testify in person, so I've elaborated on my comments, but my comments in my written testimony were simple, and that was simply a proposed amendment so that FDA cleared or FDA authorized digital therapeutics used under supervision by a licensed healthcare professional would be included, because right now they're not included in the bill, and there are currently FDA approved digital therapeutics that are used in mental health services. Basically that is a symbolic gesture of also saying something much more broad, which is the concerns that we at the Vermont Psychological Association, and you'll hear testimony that I believe we're in alignment with from Social Work Association and the Medical Society, is that we are concerned that anything that is overly broad ends up restricting our practice and bans us from evidence-based tools that are available to us inadvertently, and we really don't want that to happen. So there's some language in H816 that I feel like needs to be better identified or better defined. Let's see here. Therapeutic communication is one piece of language. I think it did go on to define it more thoroughly. But we would just ask the committee, in listening to the other testimony, to think about the definition of therapeutic communication. That could be simply an independent, independently generated appointment reminder by my EHR. And now all of a sudden that is banned, and things like that. So I think we do need to make sure that that is better defined. Also, in terms of assessment, treatment planning, I believe there were some changes to the bill, but there was originally some language that banned the use of AI in creating treatment plans, which seemed to be distinct from what was permitted in the bill. Progress notes that were edited by mental health professionals were allowed, but treatment plans somehow were excluded. I'd have to look at the bill specifically. I just want to make sure that there's consistency in what we can and can't do as licensed providers. Let's see here. The other thing is, I think the bill does go on to try to distinguish between licensed health professionals and then those seen as people outside of the licensed healthcare world. That includes wellness coaches, peer support workers that may not be certified. And I can't be more specific than other than point to it. It's curious that those are some folks that might misuse some of this material, and why licensed healthcare professionals are targeted in this way. I mean, I understand from that standpoint, but to that point, the only other thing I would add, since OPR is here, it would be helpful to have language in the bill that specifically adds OPR as a regulatory authority over some of this stuff, rather than just the Attorney General's office or the Consumer Protection Act, because we are regulated by the Office of Professional Regulation, and I believe, not to give you guys more work, but they are the regulatory authority, and I didn't see them specifically mentioned in the bill. I could be wrong about that, but I'd like to see that language added in there. I think that covers it. Again, I'm not.
Good. And you have all of that in your testimony.
No, I will. What I sent to Alyssa this morning was some of the material that I would present, oral testimony, and that I would provide. I would refine it a little bit more and submit it later today.
Thank you. That's good. Okay.
Any questions?
Questions? You're good.
Okay.
I won't ask you about the previous discussion.
No, you guys are doing good work. Thank you.
Wise man.
You got it.
Thank you. I gotta go.
Thank you very much for coming in. Appreciate it. So we'll move right along to Lynn Courier. We're skipping over Jessa deliberately. I want to Lynn. Thank you for being here. And we're on H816.
Yes, my thanks to the committee for hearing my testimony. My name is Lynn Courier. I'm the Executive Director of the National Association of Social Workers, Vermont chapter. I'm also the Executive Director of the New Hampshire chapter, and I've been a social worker for 30 years. Our primary concern is AI therapy bots independently providing mental health services. There's a lot of work in the background trying to get the language around the acceptable uses of AI by licensed mental health professionals. They're great tools. We're not talking about meditation apps. We want for clinicians to be able to use AI to generate notes. We want the clinicians to proofread the notes before they're submitted. But our primary concern is these AI therapy bots that are being marketed as an alternative, as an equivalence, that are coming out and saying, our platform's $17 a month. If you have a psychologist, it would cost you this much. If you have a social worker, it would cost you this much. It is not an equivalence. It's being put forward as, equity and access. There's a workforce. There's a shortage of mental health providers. This is not the silver bullet that we are looking for. At best, these AI therapy bots, it's unlicensed practice. At worst, it's incredibly dangerous because they are attached to these large language models that pull in from the entire internet. AI is designed to be helpful. It is designed to provide resources, to share information, to be friendly, non-judgmental, and engaging. It lacks critical thinking. It lacks critical thinking and analysis that human professionals have. AI pulls information from recorded therapy sessions, and this is how it has learned, but it hasn't actually learned. It creates predictive responses. That's what it does. In other words, if the AI system has learned that people in response to feelings of depression cut themselves, this becomes the norm. and the recommendation. AI is pattern matching. It is not deep understanding. And this is why we are so concerned about AI platforms acting independently and putting themselves and being marketed as a service. The AI verification is laughable. Studies have shown large language models exhibit racial bias. AI has no duty to warn. It cannot assist with a voluntary or an involuntary hospitalization. And AI is not a mandated reporter of suspected abuse or neglect of a child or an elder. Mental health professionals undergo education and ongoing training to achieve their license and maintain it. Artificial intelligence should not be allowed to provide services that require this licensure. All of the other piece, that's the core of it. I believe all of the other pieces about HIPAA compliance, FDA approved, I think these are all details that are being worked out. I know we're kind of working on. And I'm happy, that's my testimony. I'm happy to answer any questions that you might have.
Oh, thank you for that. It's very helpful. It sort of draws the lines for us. Yeah. It was very. Yeah. Questions for me?
This was say I hadn't thought of the mandatory reporting piece, but that's a really important point to keep bringing it up. Because if we're pushing people toward bots who don't report, it's not good.
And if I can also add, I'm lucky enough to have 4 social work interns who back in September, I said, tell me everything I need to know about this. And they're on there with these. And the bot will say, oh, I can't. My friends tell me I have this diagnosis. Oh, we can't diagnose. You need a vet. But it sounds like eventually the bot will say, yeah, it sounds like you have that. So it says that it can't diagnose, but then it goes ahead and does it anyway. So, because it
Believe whatever they see.
right, because it wants to be engaging and keep you with you. That's the marketing model.
Well, I really like what you said about an unlicensed therapy bot. That's awesome. And do you have your testimony in writing? Could we get something from you?
It has changed.
It's changed.
It's changed at 7:30 this morning, so I will
That's fine.
put it in written form instead.
That's great. Thank you. Terrific. Okay. Well, we'll go right ahead. We have OPR here and we've got VMS. Who wants to go first?
OPR wants to.
Go right ahead.
Can Director Cullen and I testify together? Is that okay with you?
Sure.
Thanks.
Just don't bring up previous.
No.
We're not going there.
I know that we will or do have filed testimony coming to you, but we will go through it, and then if it's not filed, we'll make sure that it's filed before the rest of the day.
Okay, good. Thanks.
Thank you very much for the opportunity to testify on H816. My name is Lauren Hibbert, Deputy Secretary of State, and I have with me
Jennifer Cullen, Director of the Office of Professional Regulation.
We are really grateful to be able to testify on this bill. This bill moved very quickly on the House side. We did not have the opportunity to testify on the House side. I just want to be clear because we are about to say that we don't like the structure of this bill and that we would be asking for significant changes. And that is the ask of the testimony. And so I will reach out to the sponsor of the bill on the House side. I have been in communication with the chair of the Health Committee on our concerns. And we will make sure that this testimony gets to both of them and also talk to them if this committee chooses to move in a separate direction. Obviously, that is all within your choice. This committee knows better than almost any other committee in the building, the Office of Professional Regulation regulates every profession that is mentioned in this bill, with the exception of the MDs, the allopathic physicians. We also regulate a lot of other healthcare professionals and a lot of other non-healthcare professionals. In broad strokes, we're very interested in this bill and have large concerns. The Office of Professional Regulation has our professions are in Title 26, and there are some specific professional conduct standards for each profession. You've seen those in recent bills, not to mention specific ones. And we have broad enforcement authority that touches all of our professions in Title III. And the testimony goes through what those are, but I think really important ones is it's unprofessional conduct to use advertising, if you're regulated, to use advertising, including advertising about healthcare services that is intended or has a tendency to deceive or mislead. Delegating professional responsibilities to a person who's a licensed professional knows or has reason to know is not qualified by training, education, experience, or credentials. Failing to exercise independent, I'm skipping over, I'm choosing the most relevant. Failing to exercise independent professional judgment in the performance of licensed activities when that judgment is necessary to avoid action repugnant to the obligations of the profession. Advertising or promoting or recommending a therapy or treatment in a manner intending to deceive the public. Willful misrepresentation, permitting one's name or license to be used by a person, group, or corporation when not actually in charge of, responsible for, or actively overseeing the professional services provided. So we strongly reinforce the testimony that you already heard this morning on the bill about the concern of mental health using AI and AI providing what looks, feels, and seems like mental health services without a professional attached to it. And we have concerns about the current language because as written, it is specific only to mental health services. And we are concerned that there will be the unintended consequence that other regulated professions will read the specificity of this bill as applying only to mental health and allow basically a free-for-all in the other regulated professions. So we really are concerned about that legislative intent of that it might be implied that it permits AI in other professional spaces without restriction or appropriate oversight. And this includes healthcare professions, but also architects and also dentists and all, which is a healthcare profession, so that's that example. Farmers, engineers, accountants.
Oh, I see. Land surveyors.
Land surveyors. The other core concern that we have is that this bill, in our reading, and we're not experts in AI, is really prescriptive about types of AI, and AI is moving so rapidly and so quickly that we're worried that the definitions may quickly become limiting or exclusionary, or in any case, cause a lot of unnecessary complexity. So the other piece that we've been considering and talking about, and this team was talking late into the evening last night about this testimony. So we really have been thinking about this. The complexity standards and the competency for each profession probably differs about what is the required oversight. And we think that complexity should be addressed in administrative rules by profession as opposed to by statute, which will just become really will become really cumbersome. And then for the OPR regulated individuals, they're most familiar with Titles 3 and 26. So if there were to be language around AI, we would much prefer that it be in Title 3 and 26, just because they don't go to Title 18 frequently, and that's not where we face most of our unprofessional conduct work. It's in either 26 or 3. So with those concerns and with humility about bringing them at this point in the process, we do have some recommended language, a recommended approach, and I'm going to check over to Chad.
So that'll be helpful to get your recommendations on the web page.
Great. So we have two statutes in Title III that we would recommend adding some language to emphasize.
Would someone mind just following the analysis? Why? Oh, no.
Wow, that was very.
That was very effective.
Okay, so in Title III, we have the unauthorized practice statute that makes it illegal for anyone who doesn't have a license that's required to perform professional services to perform those services. So we suggest adding language to that statute that says an entity or individual engaged in the unauthorized practice of a regulated profession through the use of any form of artificial intelligence, including chatbots and generative artificial intelligence, shall be subject to civil and criminal penalties provided in subsections B and C.
So what I'm going to suggest is you identify the places, but not give us the detail at this point, but send it in. And then we'll be able to look at that as we look at all of the recommendations that come to us.
Great. So that's one suggested change in the unauthorized practice. And then the other place where we would like to have some added language is in 3 VSA 129A, our unprofessional conduct statute, and essentially just making it very clear that using artificial intelligence as the sole independent means of doing things like diagnosing, treating, or practicing a regulated profession is unprofessional conduct. And that makes it very, very broad and makes it so that so that the public is protected in all of our professions, not just mental health.
Understood.
And the key thing for us is that we as a state license individuals because they're qualified and competent. That's what the Office of Professional Regulation ensures. And we want to make sure that that is being utilized when somebody is anticipating that they're receiving a professional service, that they're receiving the professional judgment that is implied by receiving that professional service. Sorry, I interrupted.
No, that's okay. So those are really the only two statutory changes that we feel are necessary to address OPR regulated professions specifically. And then if the committee, likes that approach, we'd recommend similar language be added to the Board of Medical Practice statutes in Title 26. We also do support the concept of including unlawful use of AI in the Vermont Consumer Protection Act in Title IX. We have reached,
which is not our area, but anything.
Yeah, we've reached out to both the Attorney General's office and the Board of Medical Practice on those issues and recommend that the committee hear from both of those. So we do feel that the proposed language provides sufficient and broad protections for the public for the use of artificial intelligence in those regulated professions, and any supplementation of those broad protections can be done in the individual professions through administrative rulemaking.
Good. Okay. So what I'm going to say is we will have you back in.
Great.
Okay. Send your comments in writing, and then as we go through markup on the bill, we'll have you back in for that. And the Senator has questions.
I don't know if it's a question. I understand that if I go into a social worker's office, the social worker just plugs in the computer and says, talk to my bot. They've got a problem. It's unprofessional. My bigger concern is the adolescent boy doesn't have money to go to the professional unless mommy and daddy. So I have to tell them first that I'm cutting myself. And I don't want the neighbors to know. I live in a small town. There's only one clinical social worker, psychologist in there. So I get on my computer and I talk to a bot. Will this bill do anything to stop that?
I think there are two features in this bill or trying to think of the language as proposed, having protections in the Vermont Consumer Protection Act, I think would
Okay.
be a protection for corporations that are using artificial intelligence, you know, in rendering professional services. And also in the unauthorized practice section, you know, if that bot is advertised as providing therapy, then the language that we're proposing would allow action against that entity for that.
Cause that to me is probably a bigger danger than
Professionals.
Professionals.
That's right.
it's maybe one that play fast and loose with the rules. But especially adolescents. I mean, yeah, good point. That was I wouldn't know how to find it. Psychology, that's fine.
So I think as Director Cohen just said, like there's a very strong history of unlicensed practice means this, licensed practice means this. And so what we need to do, and I recognize that what we're proposing is a radical shift from the current draft before you. But from our perspective, what we need to do is make sure that chatbots are seen as unlicensed practice. And then making sure that the CPA has coverage over unlicensed practice so that OPR can prosecute unlicensed practice and the attorney generals can go after unlicensed practice. And that's a partnership that frankly we already have in a lot of spaces. And this committee has delved into before with stem cell and other spaces where we have deemed like this is a space that is dangerous, ripe for danger. And so it's not unwalked territory. It's just new territory. And, you know, I think the debate about bringing this to you last night was just, is this too big at this time in the session? This touches a lot. But we think that the bill as currently before you is too prescriptive, doesn't address the chatbot concern adequately enough, and creates this legislative intent issue for the Office of Professional Regulation that we are actually pretty deeply concerned about.
Thank you. I think we need to move along. And that's I'm looking at you and wondering if we can invite you back in another time. Because we need to move on again to 9:38. I'm here around.
I'm around.
Thank you for that. Appreciate it. So we're going to hiatus while the room switches over and we're going to talk about 9:38 with Nolan and AHS.
After you go,
I went upstairs and take all the spiders.
Oh, go ahead.
No,
Go
you
ahead.
go.
Oh.
Then I run past. You know that we have a meeting. Huh? We have a, yeah. Yeah.
Yes.
Yeah.
Yes, you
Yeah,
do.
I know. You said we